and then we'll dive into advanced directives for dementia.
Sure. Oh, Steve, it's good to be with you. Thanks for having me. I am the Exit Guide Program Director for Final Exit Network, the organization that you just mentioned. We're a grassroots nonprofit that advocates for choice in dying. And the program that we're probably most known for is our Exit Guide program, which provides education to competent adults who are faced with intractable suffering from one or more medical conditions, with education on a safe and comfortable method of ending their own life, support in planning a responsible self-deliverance, which in this culture, it turns out, is quite a bit of work. And then we'll also provide companionship at the time of exit if the individual wants that. Due to laws prohibiting assistance, we cannot provide the equipment and we cannot provide physical support. But other than that, we are available to support people. You know, you asked a little about me. Choice in dying is kind of something I grew up with. You know, my parents were both, I think, really affected by the Nancy Cruzan case. And they had my brother and me signing our first advance directives at the tender age of 16. So,
Wow.
yeah, so I grew up with this, and it's really a passion.
Were your parents activists, or like what do you think led them to um uh take such an interest in that and instill that culture in your family?
You know, they were both highly intellectual. And I think, like so many of us now, they had seen endings that they did not want for themselves. And
Hmm.
then also, as I said, things like the Nancy Cruzan case or the Karen Ann Quinlan case, realizing that it wasn't just at the end of life. And so
Yeah,
looking to us and saying, yeah, we don't want to be in that position.
man, that's the what a gift to you and your family for them to be thinking that way and to introduce you to that. And it's great that you're carrying on the legacy of your family here with Final Exit. That's excellent.
Yeah.
So let's dive into this. I already see, and folks, we love these discussions to be interactive. And I already see Chuck's got a great question in the queue. Chuck, we're going to jump on that. But before we do, let's provide an introduction to this topic. And, advanced directives for dementia. Is this different than an advanced directive, or how should we be thinking about this?
Um, so in general, yes, it is different than an advanced directive, with the one exception that I'm aware of being the state of Nevada. When you think about an advanced directive, and it sounds like you've had discussions about those in the past, those are described in state statute. Every state sort of has a form that you can fill out that is recognized by healthcare practitioners, that is recognized under the umbrella of the law. And in an advanced directive, you would specify what kinds of treatment you would and would not want should you become incapacitated and unable to speak for yourself. And it also, usually there's another form that allows you to appoint someone else to be your healthcare representative, also called a proxy or a surrogate or power of attorney. Different states have different words for it. Um, and so an advanced directive and the appointment of a healthcare representative are sort of this bedrock of get something down, get down what you want, what your values are, so that people have some idea should you become incapacitated. And as I said, these are recognized in state statute. And I'm hammering on that because when it comes to advanced directives for dementia, these are not described in state statute.
Hmm.
They're not officially recognized. So one of the questions that's hovering out there, a little bit brought up by Chuck here, is will they be honored? There have been some legal test cases in Australia and UK and Canada that were a bit older, sometimes working, sometimes people having expressed their wishes pretty clearly, and yet when challenged by a healthcare facility that didn't want to honor them, the courts did not support the individual who had expressed their wishes. Partly in response to those cases, the sort of modern group of dementia directives were developed, really trying to plug the holes where lawyers could argue that the dementia directive isn't relevant or doesn't apply or isn't well written. But we don't have a test case in this country. So we don't actually know how they'll hold up in front of a court.
Hmm.
And one of the interesting things that makes US law difficult is that typically you can't go to court until you have an issue that is, I guess, called ripe. I'm not an attorney, by the way, but by the time an issue is ripe, you're in deep dementia. Your healthcare representative is instructing the healthcare facility to honor your wishes. The healthcare facility is saying, no, we refuse. The wheels of law move slowly. By the time it gets through, the person's already dead. So we don't have a test case.
Wow. Okay. Well, I say let's dive in with Chuck's question. And also, folks, what I did, I dropped in, and let me share my screen because I dropped in links to the Final Exit Network. But they on their website, they have a page here specifically on you'll see under services when you go to Final Exit Network, it's Advanced Directives for Dementia, and there's a page here on Advanced Directives for Dementia. I dropped in the definition there on your website, and then they have some suggestions on forms which we can dive into a little bit later in our discussion. But let's use Chuck's. I love being able to respond to questions. And let's use Chuck's question as a way to kick this off. And Chuck says, my advanced directive says that when I'm at a 6 to 7 on the Alzheimer's scale, my agent shall prohibit 11 medical interventions. One of them is no hand feeding of liquids and food. Is my trigger for my agent taking over workable? Is it going to be hard to get no hand feeding directive enforced? How can I maximize the likelihood that it will be enforced, perhaps in a nursing home? And folks, I'm gonna cut and paste that into chat so everybody can see that question because I didn't do the greatest job of reading it. But Lowrey, give us feedback on Chuck and his insights. And number one, Chuck, hey, hats off for being prepared enough to have an advanced directive and to be even addressing this in your advanced directive. But what are your thoughts, Lowrey?
Yeah, well, I saw that question come in. I was like, okay, this is gonna be a hard-hitting crowd. I think I don't know where they're coming from. Um, so, well, the first thing I would note is he brings up this question of 11 medical interventions. So one of the areas in past legal cases where there's been a question is hand feeding medical care, or is that basic care? And a lot of residential communities, nursing homes in particular, are legally required to provide basic care. So it's very clearly recognized from Supreme Court decisions that any competent adult and or their healthcare representative can say no to medical interventions. The question is, okay, is hand feeding a medical intervention or is that basic care? So some of the advanced directives for dementia, which are, as I said, are like a supplement to your regular advanced directive. It's not one or the other, you would have both. Do try to say, look, I don't care what you call it, I don't want it.
Okay.
It is certainly recognized that a competent adult who is still competent can refuse food and fluid. So it should be that your healthcare representative should also be able to do that. So his trigger is he's using, one of the scales, in this case, the Alzheimer's scale. There's a couple others. There's like the FAST scale. Don't ask me what FAST stands for. So 6, 7 would be very severe dementia. That would be end stage dementia. It's a reasonably workable trigger. I think the issues there are that where people want to see it, they bump it up, and where they don't, they bump it back. These kinds of things are very subjective. It's going to depend a lot on who's making that evaluation. And it's important to remember that dementia does fluctuate. You can have like one good day followed by weeks of being relatively comatose. I think the biggest thing that one can do to try to buffer your advance directive as best you can is you do want to appoint a really solid healthcare representative. When you're thinking about who you're going to choose as your healthcare representative, it is not a popularity contest. You want someone who is firm, who can stand up to authority, who is comfortable and understands that at some time in your life trajectory, their job is actually to see that you die as quickly as possible. Because essentially that's what the dementia directives that are requesting voluntarily stopping eating and drinking in late stage dementia do. And that makes me think we should pause for just a second and jump back, because is that okay?
Oh, absolutely. No,
Okay.
I knew Chuck's question would sort of be a great a real life story, you know, a trigger for a dialogue here around this. This is wonderful.
Yeah. Well, unfortunately, it was too good a question, and it got me right into the weeds.
Yeah.
Um, so in Final Exit Network and the work that I do, we're really very focused, and the people that we serve are focused on hastening death in the face of dementia. The people that we serve want to spend as little time as possible in a demented state. That is not everybody's values. There are other people who want to live to see every day, who might have other values. So do know that when I'm speaking, the perspective I am coming from is mostly from the people who are really saying, hey, how can I shorten time in dementia?
Hmm.
And so the dementia directives, like the two that you pointed out on our website, are directives that call for voluntarily stopping eating and drinking, which is a method of self-deliverance, in late stage dementia. If that is not your priority, there are other dementia directives where you can discuss a little bit more, like where you might want to live. Would you be interested in participating in research? Dartmouth actually has a dementia directive that's a little bit more broad and has a bunch of these other options for people who might like to explore some of those choices. But my area of expertise tends to be the directives on, how can I shorten the amount of time and die as quickly as possible when faced with dementia.
I love it. And Chuck, thank you so much for your detailed question because I have I guess in these discussions, we've talked about dementia scales before, but I wasn't fully aware of it. But just to, I dropped in, so that the FAST scale is the Riceberg Functional Assessment Staging Scale, and I dropped in a link to that. But the one that Chuck is referring to, let me share my screen real quick here because in the context of our discussion here it's sort of as we look at this scale and we see here Chuck said when I'm at a 6 or 7 on the Alzheimer's scale my agent shall prohibit this care is that stage 6 severe cognitive decline, cannot carry out ADLs without help, forgets names of family members, forgets recent events, forgets major events in the past, difficult counting down from 10, incontinence, difficulty speaking, personality and emotional changes, delusions, compulsion, anxiety, and stage 7 cannot speak or communicate, require help with most activities, loss of motor skills, cannot walk. So what you're saying, Lowrey, is that, and correct me if I'm evaluating this, is that some people might say if I get to 6 or 7, um, I do not want to be living in that state. That is not a quality of life. That is not how I visualize myself living. And therefore, I want directions to not live in that state for for an extended period of time, I should say.
Yeah.
Okay.
Um, and that does make me think in terms of that trigger, you do have this somewhat subjective scale of 6, 7. As so many things in life, there's the legal and then there's the reality and what happens on the ground. When you think of advanced directives for dementia that call for voluntarily stopping eating and drinking, as a practical matter, they are only going to kick in when the individual in question is no longer expressing any interest in food or fluid. Like it is just not in many ways, perhaps not fair to ask your caregivers to turn to someone who is saying, I'm thirsty, and saying, I'm not going to give you a drink. It's
Yeah.
just not a reasonable thing to ask your caregivers to do. So it really will be very late stage dementia when that would happen. And it is at that point that your healthcare representative would turn to the facility and say, hey, look, this is how this needs to happen. You need to stop providing this. And as Chuck is asking, that can be difficult. Some people can feel more ambiguity about supporting somebody else's choice in that. Obviously, a lot of these facilities are very risk averse. They're worried that they might be sanctioned for it. So your healthcare representative may have to fight. And one thing I would note too, just thinking about Final Exit Network and what we do, because we don't yet have a legal test case setting precedent in this country, we as an organization are very interested in having that happen. So if any of your listeners are the healthcare representative for somebody and they are trying to get a clearly written advance directive for dementia honored, and a facility is not honoring it and the request is unambiguous, we may be able to provide legal counsel to get that case through the courts. So
Wow. No, this is great to know. And folks, I will now I will make sure to put the contact info in for Final Exit Network and what have you. All right. I see we're getting comments and questions. This is amazing, folks. Okay. Chuck follows up with his question in saying many states have mandatory feeding provisions, not DC. So Alzheimer's disease and no hand feeding comes into conflict with these laws. Okay, I'm not sure if I read that correctly. Do you understand what he's saying there? Many states have mandatory feeding provisions, not DC. So Alzheimer's disease and no hand feeding comes into conflict with these laws. I think that's one thing that you were stating, Lowrey.
the sort of debate, whether it's basic care or medical care, at the end of the day, a competent adult is allowed to decline food and fluid, and therefore the healthcare representative of an incapacitated adult should be able to make that choice as well, especially, and in fact, they should make that choice if the individual, when competent, specified that that's the choice they wanted made. But you do, as I said, you get risk-averse facilities that don't want to be sanctioned for starving their residents.
All right. Let's see. Rick's question, which I'm going to drop into chat so everybody can read it, says, my directive says if I cannot recognize my family and the chance of recovery is deemed not to be likely after 30 days, I want a healthcare, an HPM. What's HPM? I want an HPM consult and a VSED started. Take me out of the facility and to a site that allows VSED. And forgive me, do you know what these acronyms stand for, HPM and VSED?
I don't know HPM, but VSED is voluntarily stopping eating and drinking. Oh, and
Okay.
HPM is hospice and palliative medicine.
Okay, got it. Got it. Thank you. Thank you.
So the hospice palliative medicine would keep you comfortable while you are voluntarily stopping eating and drinking.
Okay, excellent. Rick, that's I just love it that we've got people here on this call that are really thinking about this and taking steps to make sure that their wishes are heard. This is amazing. And I'm dropping in as quickly as I can links to some of these things that Rick was talking about there.
And I'll jump into, Rick brings up again one of these great points about getting your directive honored and the trigger. What is the trigger to start the voluntarily stopping eating and drinking process? And one of the ones that shows up on almost all of the advance directives for dementia that different organizations have written is when I no longer recognize friends and family. It's a perfectly good one. Not we all, but those of us who don't want to live in that state clearly recognize that. There's a couple of problems with it, which doesn't mean you shouldn't use it, but remembering the fluctuating nature of dementia, there'll be a point where from time to time you don't recognize your loved ones, or you might recognize the loved one in the sense that I recognize this as a loved one, but I don't remember whether you're my daughter or my aunt or my sister. And then there's the times when I don't recognize you. So when you look at things like that, is the trigger when you never recognize them? Or is the trigger when you start to not recognize them from time to time, right? That could be a breadth of time. And I will also share, to me, a somewhat terrifying, but also really interesting case study. I was at a conference in Utah earlier this year, and Hope Wenchkin, who's a hospice either director or nurse in the Pacific Northwest somewhere, just presented this case study of this woman who was in very deep stage dementia, was probably awake for 2 hours a day, would get up to sort of eat, bathe, and be pretty much comatose the rest of the time. Her brother, who was her legally appointed healthcare representative, did not live nearby. He came back after 6 months, was sort of horrified, and said she would not have wanted this. She has this directive, start voluntarily stopping eating and drinking, or VSED, immediately. Her sister lived nearby and visited regularly, and she had a caregiver who worked with her every day. Now, the patient had two phrases: help me and I love you. Those are the only things she could say. But you had the sister and the caregiver saying, yes, she does recognize us. Like when I come in, she reacts. She may not say my name, but she clearly recognizes me. Whereas the brother, who was the legal healthcare representative, was out of town, and they said, well, she doesn't recognize you because you haven't been here. So it actually, they had to bring everybody together and sort of come to some kind of consensus. But it wasn't as clean a process as the lawyers would have said. But you had all of these people who were saying, well, they were disagreeing. Has the trigger been met or not?
Mm-hmm. Wow. Now and let me share my screen again here. So one of the things on the final exit network page on Advance Directive for dementia is, if you scroll down, you see two advanced directives for dementia that you all are sharing with folks. One is from Compassion and Choices, the other is from the Northwest Justice Project. My assumption is that you all have reviewed these, and the language in them is more specific so that there's less ambiguity in the if somebody is actually executing those. Is that the case?
Um, yeah, we reviewed a bunch of them, and also just realized that a lot of our viewers and website visitors don't think that poring over 10 different advanced directives to choose their favorite is their idea of a good weekend activity. Um, we chose those two for, yeah, precisely the reason that you describe. They seem pretty clear. They seem pretty simple, particularly that's an older version of a Compassion and Choices dementia directive, but we really liked it. It's clean, short, simple, really easy to fill out. If you're just going to get something in place, that's a good one. And it seems to hit the important points and be simple enough that it's clear, less you can argue about. The Northwest Justice Project one is a much more recent one, just came out, I think, this year. A bunch of good minds went onto that one, including Paul Menzel and Thad Pope, who've done a lot of work in this arena. It has a few more choices, so it's a little bit less simple to fill out, although really pretty simple, but also just covers a few more angles. So we thought those two were probably the best. But as I said, we haven't been able to test any of them in court, so that's just our reading of them.
Okay, great. And I'm dropping that link into chat again. And the other thing that you mention on there is that, and there's a link to the Dartmouth Advanced Directive for Dementia, which tends to focus a little bit more on not necessarily ending the life of, okay, if I'm at 6 or 7, please, let's I'm not using the correct terminology here, but
I would
more,
like to die as
I
quickly as
would I would
possible.
like to die as quickly as possible,
Uh,
but more on, hey, if I'm at a 6 or 7, make sure that I'm in a secure dementia unit, or this is how I'd like to be cared for, or what have you.
Exactly.
Okay, great. This is great information. Okay, let me go back to a couple of questions here. Okay, here, let me drop in Chuck's 11 interventions that he had in outlined in his. Chuck, you get the gold star today for participation. This is awesome. He also says, my advance directive has 7 pages on dementia, basically a legal brief defending the 11 no's and hand feeding no. If I'm going out, I would love to be a test case that validates my choices. Hats off, Chuck, and thanks for joining us today and sharing these resources. And somebody says, Chuck, would you be willing to share how and whether you have chosen your advance directive health agent and whether you have chosen a backup in person and what it was like having the talk and conversation with your agents? Thank you for your good questions and information. And Chuck, you're a wealth of first person knowledge here, as somebody who's done that. If you'd be willing to come on and verbally sort of share how you picked your health agent, I think that would be very beneficial. Just raise your hand if you'd like to do that, and I can open up your mic and you can share that verbally, because I think responding to this person's question in writing and having me read it would probably not be the easiest for anybody to understand. But what you do is you got that little virtual hand at the bottom of your screen. It says raise hand. If you'd be willing to do that, just raise your hand and oh, Chuck's going to be on there. Okay. Chuck, I will get to you in one moment here. I'm actually going to I'm going to allow you to talk, and then we can also, if you, uh, um, want to share that. But Chuck, let me just quickly go through here before I uh, bring you on there. Let me just make sure that we don't have any other relative questions. Okay, Lowry. Rick asks, what are the 5 most important qualities of, well, you know what? Let's talk to Chuck. Chuck, I think you're going to answer this in your first person questions. Chuck, number one, thank you. Can you hear me?
Yes, I can.
Okay, great. So the question that we had earlier was, Chuck, would you be willing to share how and whether you have chosen your advanced directive healthcare agent, and have you chosen a backup? But tell us how you chose your agent, and have you thought about a backup?
You always need a backup because somebody might not be available. I mean, maybe you want backups who are a good deal younger than you are, so that they will be around for a long period of time. It's best that they're local, so that they might actually be able to go to a facility where you are. I mean, if you have a problem somewhere, but with dementia, this is going to be a slow process. You're probably going to be near your home and that kind of stuff. But to be clear, you need a very, very, very tough fighting agent who is going to go into a facility, maybe a hospital, maybe a nursing home, and fight for your choices. Now, and there may be a fight because of these mandatory feeding laws in many, many states, which look to be somewhat in conflict with a no-hand feeding provision. I mean, they were put there so that they wouldn't be elder abuse by a nursing home that was saving money on food or something. But they do look to be somewhat in conflict with a no-hand feeding provision. And your agent may need to fight and may need to litigate or move you out of that nursing home to another place or take you home. But
So
I
if
think
you
the key is, and what I've said in my brief, in my advance directive, is they are completely legally immune to any second guessing about if they take me home and if I'm asking for food, yes, I think they cannot take it away from you. But if I'm comatose, you're not comatose, but I'm completely passive regarding food and liquids, and they take it away, they cannot be prosecuted for killing me. I mean, there are problems here when you take aggressive steps like this to deprive them of food. But if look at you've got to be ready in your advance directive. If it is quiet on dementia, you are in terrible trouble. You have got a massive problem in your advance directive, because the one thing I think people don't talk about is dementia, because they do their advance directives when they're 40 or 50 and they're not thinking about dementia.
Yeah, no, I tend to agree, and this is why this is such a great discussion topic. Now, Chuck, you're very thoughtful in this area. How did you choose your administrators, or I'm blanking on what you call the person that
Agent.
how did you choose your agent and your backup, and what kind of dialogue have you had with them on this?
Well, the first agent is my wife, and I'm her agent, and we testified together in favor of the death with dignity statute in the district, and favorably mentioned final exit network as an alternative to the Oregon law. And both of us said in testimony that is on the public record that whatever it takes, we will find a way to help the other end their life under the terms of the living will. I mean, we've said that in public. And we basically said we would risk prosecution if it came to that, because we believe so much that because we have lived a dignified life, that we do not want to go out in terrible suffering, pain, or dementia. So, and my backups are similar to understand my position and understand her position, and we feel like they will fight for us.
Wow, this is great. Boy, you've really led. You've really offered some great content, and in fact, I know it's so great because somebody's asking. It's sort of like, "Hey, Chuck, what's your email?" Chuck, if you're willing to share your email and contact info,
Well, could I email it to you?
well, I would just. Why don't you drop it into chat? And if you're open to that,
Sure.
and that way, if there are folks on here that like to have a dialogue with you,
But to be clear, we know about the Oregon law, that there are 11 states with the Oregon law, but it doesn't work for dementia. You couldn't do phys ed, voluntary cessation of eating and drinking, because you don't have the mental commitment to do it when you get dementia. So phys ed doesn't work when you have dementia. And a number of the other ways in which, to do the medical aid in dying, if you've got dementia, you don't qualify for that. You aren't mentally capable of deciding and getting the doctor's prescription. So it's a massive hole in the whole field of advanced directives, and the medical aid in dying won't help you.
and I'm glad you brought that up, because before we started talking, number one, Lowrey is in Oregon, and you brought this up in our pre-discussion, Lowrey, is that you can have this advanced directive, but you are unable to give direction on your end of life wishes if you've got dementia, correct?
So typically in early stage dementia, in mild dementia, typically people retain decisional capacity for making things like medical choices. When you start moving into moderate or mid-stage dementia, typically you do not retain capacity, and so couldn't put those instructions in place. But yes, if you have a very early diagnosis, you can write a dementia directive at that time. And actually, Chuck's comment reminds me of sort of what you and I were talking about. For those people who want to shorten the amount of time they spend in dementia, there's currently two options. And I will quote researcher Dina Davis, who talks about the missing middle. If you have a dementia diagnosis and you wish to hasten your death and experience less dementia, you sort of have two choices. You can either end your life while you are still retain your decisional capacity in early stage dementia, or you can have a advance directive for dementia that calls for voluntarily stopping eating and drinking in late stage dementia, when you've reached the point where you're no longer showing any interest in food. But for that period in the middle, when you don't retain decisional capacity, but you still express an interest in food, there's no options. You're pretty much stuck. So when you're looking at your future, thinking about what your values are, for some of us, dementia is such a horror that we would rather end our lives early and probably leave some good life on the table, because in early stage dementia, you're still, able to participate and, can get some good quality life. So for people who don't want to end their life in that window, you sort of have to wait till later stage dementia.
Mhm. Um, I'd love Chuck for you to hang on here for a little bit here, because Rick's question is, and this for Rick and for Lowrey and Chuck, what is your opinion on the role of engaging a trusted medical decision maker during the facilitating of the directives and enhancement of the directive with a video clip? Any thoughts on that?
Sure. I mean, anything you can do to show intent and that you really are committed to it and you really mean it, and a video would be possible, or an especially detailed living will would be possible. But to be clear, the living will only operates when you cannot make your own decisions. I mean, if you're comatose or something like that. So it can make comments about how I want to live my life, but if I'm decisional, I just make those decisions directly.
Right,
I
right.
could do phys ed maybe at some early stages of Alzheimer's,
Mhm.
but once you get further into Alzheimer's, you can't make the decision. You don't have the willpower. Phys ed takes a commitment to end your life with no eating and no drinking, and people do it. I think it's very, very common actually, and unsung. But it takes intent, because you're going to have some suffering. They can medicate you for the hunger pangs and whatever, but stopping drinking is the key. You stop eating, you can go on for weeks. If you
Yeah.
stop liquids and nutrition, you're out of here in like 7 or 8 days. And but you've got to be very decisional to do that. And if you've got dementia, there's no way in the world you could do visit
Mm,
or medical aided dying.
wow.
Well, as I said
Um,
earlier, medical aid in dying is off the table if dementia is the qualifying illness. And Chuck raises a good point too about video. I think a lot more people now are also just using video in their regular advance directives to supplement what they're saying.
mhm.
The other question that came in there is, should you involve your healthcare agent or your healthcare representative in the drafting of your dementia directive or your advance directive? Yes and no. One part of that is excellent. In all of these conversations about how to make sure your wishes are honored, the more that your close loved ones understand what you want, respect what you want, and support you, the more likely you will have an ending that you want. It would be nice to say that your wishes are yours alone, but we are social animals, and especially when you're no longer competent to make your own decisions, others are going to be making those choices for you. So we always advise people, talk early, talk often. Yes, your loved ones should be rolling their eyes, not this discussion again, because no matter how much you've talked about it, when you actually get to that point, for your loved ones to start making choices that are going to cause your death, that is a tough shift to make, and you need to prepare them for it. So have a lot of conversations. And don't, check with your healthcare representative. Say, these are my wishes. I am going to want you to have to make these difficult choices. Are you comfortable doing that? Like, because that is important. You don't want to choose somebody who is a beloved relative, but who has different values about end of life than
Mm,
you do.
There's
yeah.
another alternative, and that is to have a contract between you, when you're cognitive, and your doctor. And there's a legal form for this, and it basically is not simply you stating what you want, but it's getting your physician to agree to it. Now, I actually changed my physician because my previous one was not even interested in helping me with medical aid in dying, let alone the no hand feeding. So I changed physicians.
Hmm. Wow. Yeah, Chuck, man, you're golden to be on this discussion. This is amazing. I'm gonna keep you on there as I keep on answering reading these questions. Vivian says, if I have a robust dementia clause in my advance directive that contradicts my wishes when I'm in advanced dementia, what can I do proactively to make sure that my wish when I was compos metis will prevail? So I guess that would be, you spelled out exactly what you want, but in your demented state, is sort of like what you were saying, Lowry, where it's sort of like I'm hungry, I'm happy, but she doesn't recognize. Any thoughts on this one?
I mean, as I said, it's going to be very difficult for caregivers not to provide food and fluid to someone who is asking for it.
Yeah.
But a number of these dementia directives that are being written now do directly address the question of, even if I appear happy. And some of them will have a checkbox that says, if I appear happy, my healthcare agent does or does not have the option to reinterpret my directive. So some directives do specifically call out that one, like, I don't care how happy I look, I want you to do this. Or depending on how happy I look, my healthcare agent can go one way or another.
It
Okay.
isn't entirely clear whether it varies by state, I think, whether the agent is bound by your living will. Because you give the agent power, but I think it depends on the state or the legal jurisdiction of whether they are bound to actually do exactly what you told them to do or whether they have discretion.
Okay. Let's see. Here's one. If a patient with dementia is later diagnosed with end-stage kidney disease and the medical team advises dialysis, yet the patient does not understand this procedure, can they force this patient to sit for the treatment long term?
Well, presumably, if the person no longer has decisional capacity, it would be their healthcare agent who would be making that choice. If their healthcare agent said, yes, that would be an appropriate treatment and this person would want it, they would probably do their best to administer the treatment using sedation if needed. But I'm not an attorney. That's kind of getting outside
Okay.
the
Well,
bounds.
you need, I have 11 no's in my advance directive. I mean, 11 things they cannot do, and dialysis is certainly one of them. And no intravenous and no intubation. And I've got 11 no's, only one of which is no hand feeding.
Wow. Okay.
Well, that's where it's helpful, right? If this person had had that specifically in there, then that speaks for the person. But it would be your healthcare representative who's holding your piece of paper up and saying, this is what he wanted.
Oh, Lowry, please restate the name of the expert who referred to the middle space in dementia.
Dina Davis
Okay.
has done some research. I know she's written a paper on Alzheimer's diagnostic testing and preemptive suicide, and really trying to open up this discussion about, people who do not want to go into dementia, wanting to hasten their death early, and very frustrated that the society at large is not having these discussions. So it's an interesting paper that she wrote.
Okay, and is she from Ottawa?
No, she used to teach at Lehigh.
Oh, okay. All right. Okay.
Let me put a point on this. There are studies that show that the financial health of the family with somebody with dementia who hangs on for a long time is utterly disastrous. I mean, it's aside not just the quality of life, but bankruptcy. And I mean, people know what I think memory care is a completely inappropriate a word in many cases for late stage Alzheimer's. I mean, these are people who are gone. And the idea that they will hang on for 2, 3, 4 years. And I know one case where they hung on for 10 years, utterly destroyed the family, destroyed the kids, destroyed the spouse, and destroyed the finances. This is not the way to end your life.
Okay, this is great. Okay, and I found an article that Dina Davis wrote here, so hopefully that's helpful to the person that asked that question. And let's see, I'm looking at the clock. Okay, we got about 10 minutes to the top of the hour. Got a bunch of questions here. Let's try to get through them. Vivian says, if a dementia clause in advance directives has not been tested in court, doesn't that mean it's a good document that tends not to be challenged? And it would be compiled without questions.
Unfortunately, no. As I said, I think a little bit earlier, if a facility refuses to honor it, you already have a patient who's in late stage dementia. The wheels of justice turn really slowly getting through the court system. So a lot of times these cases don't actually get to completion or even get to court because it takes too long. So we are, as I said, waiting for some case precedent, but we're not aware of cases that have gone through and have a judgment yet. And it's not just because they're accepted willy-nilly, because we hear time and again that they're not, that families really have to struggle. You know, even Hope Wedgkin's case study, where most people were really operating in good faith and trying to take as good care of the patient as possible, they were having trouble sort of coming to some consensus about what was the trigger, what would she have wanted.
One thing you can do is if you're in a facility, I mean, if you're at home, you're at home. I think you got control of that. If you're in a facility, you can give them the living will in advance, right when you get there. In fact, they'll probably ask for it, and you can ask them whether they're going to follow it.
That is actually one good point, because usually by the time you are in late stage dementia, you're needing round the clock care. It would be very difficult for you to be in somebody else's home. So you can certainly, and probably should, approach any facility that you're considering living at, or your healthcare representative should approach them and say, look, this is coming. You know, I want you to be aware of it. Is that going to be a problem? Do we need to look for a different residence? Anything that you can do to grease the skids. Obviously, yes, Chuck's absolutely right. All of these things are so much easier to put in place if you are at home. The problem is by the time you are in advanced stage dementia, you are needing so much care that it would be very difficult for you to be at home.
There is, I think, only one state, Nevada, that has something of a law in this space. But given the mandatory feeding laws, which are quite common, I think it's important at some point to have legislation and to clarify that by the way, no, the mandatory feeding law is not meant to apply in contradiction to a living will that talks about hand feeding. I mean, it would be helpful if we had legislative clarification in this space. I know of, I've attempted to work with Compassionate Choices in this space to look for a state which, I mean, they do the MAID laws. Look for some state where they could set up a test law, which would clarify this space, which would be helpful, especially if there's mandatory feeding laws that look to be in contradiction. But we, you know, and then the state laws vary on what they say about how mandatory the agent must follow the wills, the provision of the living will. DC says they must follow it. I'm not sure whether that's enforceable. I think the agent probably has legally some discretion, even to contradict what is in the living will. I mean, these are lots of fuzzy areas here.
Man, this is great. Okay, we're getting close to the top of the hour. Just a reminder to everybody, this is recorded. If Lowrey, if you can hang on for a little bit longer, we'll get through a few more of these questions. Okay, folks, I copied two questions. One was from Rick on the conundrum. A person has been deemed to lack capacity, but caregivers are still feeding him, even though the directive says not to do this form of care. This seems to be totally inappropriate. And I think we all agree on that here in this dialogue. And then Catherine is saying there needs to be an honest conversation about how there is a range of hand feeding for those with dementia at a private home versus a facility setting, training of the person to hand feed, being able to understand nonverbal cues, etc. I don't know if either one of you would care to comment on Catherine's comment about that.
Actually, that is interesting. In the example, in the case study that I talked about, what the family and the caregivers eventually came to is something that is called comfort feeding only. So they didn't sort of do the full voluntarily stopping eating and drinking, sort of actively withholding stuff. But when her interest was expressed, they would give her a little, but not encourage, not put the spoon to her mouth. So that is kind of a middle ground. And I believe it's called comfort feeding only.
Well, there's also terminal sedation, which is another, sometimes they get to a point where the person's in pain or whatever it is. And I think this is a bit deceitful in the sense that I think doctors know that they are giving the patients too much sedation. I think they know it. They even call it terminal sedation. And sometimes it is literally terminal sedation, but other times I think it is a way for doctors to legally, sort of legally, to end a life in compliance with a living will. And I think quite bizarre, the Catholic Church actually supports terminal sedation. They oppose the medical aid in dying, and yet they find terminal sedation to be reasonable. Help me.
Well, Chuck, actually, what's interesting, Elva says it's important not to go to a Catholic hospital at end of life if you want to control treatments versus non-treatment. That just popped up right when you were talking about the Catholic religion.
Well, and it is tough, unfortunately, as so many things in life. Who your healthcare representative is will make a big difference. Who your care providers are can make a big difference. There are some physicians who are much more comfortable with terminal sedation. Regardless, terminal sedation is only going to be used where you are pretty close to the end of death anyway. So especially sometimes if somebody is using voluntarily stopping eating and drinking, terminal sedation could sort of make that process a little shorter. It's sort of this law of double effect. It is perfectly legal to give a patient so much sedation that it ends up hastening death, as long as the reason the medication is given is to relieve suffering.
Mm-hmm.
It's a little bit of a dance.
I want to make sure to address this question here, and because solo aging is one of our main topics of discussion here, and someone asked, what are the options for people that do not have available healthcare agents? I know we could do at least 2 hours on this topic, but I want to throw that out to both of you.
You can, if you have a family lawyer, you can see if they would be willing to be a fiduciary, because this is a difficult spot. You do need somebody. There are sort of some growing professions of healthcare advocates. I know there's two organizations. I know, Steve, you type a lot faster than I do. There's the Alliance of Professional Health Advocates. They might have a directory. You could try to find someone near you. There's also the National Association of Healthcare Advocacy. Those are two places you might look to find a professional who you could hire to be your healthcare representative. Typically, these people would only charge for when they're actually active. So you would engage them while you're still of sound mind, and then they would step in when you could no longer speak for yourself.
I would guess the largest problem in this space is that people need to deal with these issues 10 years before this is going to be a problem. And at that point, I know a case where somebody that I know well, and I knew the spouse quite well, and I raised the question of what the Advance Directive would say about dementia. And I went through all of the 9 yards of what I was proposing and how firmly I felt about it. And the husband said, if I get dementia, I want to live as long as possible. And it is a disaster in that household now. He is now beyond the point where he can revise or do a new living will. It's a complete disaster.
This is great. Okay, I'm scanning the chat, and I try to address everybody's comments and what have you. But and Nancy says this is the most comprehensive and excellent discussion I've experienced about these important issues. Yeah, I agree, Nancy. This is Lowrey, and having Chuck on, somebody that's doing this for himself, has really been a great, authentic conversation. Nicole Smith states estimate state caring for someone with dementia is a $350,000 private pay cost. And I think for those of us that are thinking about this is that, and we think about our loved ones, and we think about how much we've got in our bank accounts, and we think about our own personal quality of life, you can see how it's sort of like, do I want my family to be paying? Do I want my estate to be paying for my care at number 6 and 7? And this is a person on that stage. This is a personal choice for all of us, folks, you know.
And it's important to remember that many people don't have that kind of money. I want to say the Alzheimer's Association recently put out a somewhat interesting report, really looking closely at the impact, particularly on women who end up being most of the time the caregivers, not always. Being a caregiver is obviously very difficult on quality of life. It can also be devastating on somebody's health. It becomes exhausting. It sort of creeps up on you over time. The needs become more and more, and you don't notice the changes. And so it can have a health impact on your loved ones as well.
I think the whole point for me is the better your life has been when you were healthy, the more outrageous it is that you would go out this way.
Mm.
And to have such a disaster with no capacity to engage with people in any reasonable way, no capacity to learn, no capacity to be curious, no capacity to run around, to travel, inflicting terrible burdens on your family. I mean, if you've lived a great life, this is impossible to think that this is the way you're going to die.
Yeah.
I do want to jump in here, though. I mean, I do certainly, how Chuck is expressing it is how I feel personally for myself. But I do think we need to recognize that there are other people who feel differently. There are some, there are a lot of people who, whether for religious reasons or just they want to live to see as many sunrises as they can. And that's important. We need to make sure that that is an option. And I think that if those of us who want to end our lives earlier are able to do so much more easily right now, that is such a difficult choice. And it feels like hurdles are thrown in the way. We're the people who are saying, look, we don't want to be here. This isn't what we want. Let's put those resources towards the people who do. I mean, I think we can meet both of those and respect everybody's desires for what they want for themselves should they develop dementia.
One thing that would be crucial, but will never, ever happen, is for the Alzheimer's Association to deal with this issue and give people realistic living will options for Alzheimer's or Lewy body dementia or whatever it is. These associations are, it's all about treatment. It's all about curing. It's all about medical research. Well, in the meantime, we've got 10 million people with Alzheimer's now, and it's going to be many, many more than that. They will never be honest about these issues, I'm sorry to say.
I do share Chuck's frustration. The disease organizations in general, I don't quite understand it, because if you want to care for a group of people, making sure that that group has all of the options available, and hastening death is one of those options, but certainly Find Lexit Network has not had any luck making inroads with the disease organizations.
Yeah. This has been amazing. Thank you, Lowrey, for introducing this topic, and Chuck and everybody on who sort of shared in this great discussion. I think this is something that we should continue and make sure that we do this on a regular basis, because we want to keep this on people's radar. And
I think it's like 1 or 2% of the living wills mention Alzheimer's.
Wow.
And if you don't mention Alzheimer's and there's no trigger, and you don't have, I put in hand feeding as a fallback in case the other 10 no's didn't work, because I didn't need intubation or I didn't need, something else. And I put in hand feeding as the clincher that would absolutely end my life if I'm a 6 or a 7. But almost nobody says anything one way or the other in a living will.
Now, Chuck, I'm always curious about, people's stories. Was there something that you experienced in your life that caused you to take an interest in this area and be so prepared for you and your family's end of life wishes?
Well, I spent 35 years on Capitol Hill and in the White House, and I was the principal lobbyist for the whole biotech industry. So I am very steeped in bioethics and medical issues, Alzheimer's research, drafting laws, dealing with regulations, dealing with legal matters. So, and when we worked on the medical aid in dying, which we got in the district, my wife and I were important players in that. it was obvious to me at the time that it wouldn't help for Alzheimer's or dementia.
And I'd like Lewis's comment to, in your directive, it would be safer to just use dementia or any type of dementia, because although Alzheimer's is a very common form of dementia and it is a name most people recognize, there are a number of different types of dementia. There's Lewy body, frontotemporal, and some other ones as well.
I think Alzheimer's is probably 80% of it or something like that, but you can't diagnose it without an autopsy probably. So at some point, it'll be interesting. They will have a medical test for Alzheimer's and maybe for Lewy body and some of the others. They will actually have a blood test or a genetic test or something else, and you will absolutely know you have got it. You're not just a little vague, getting older and a little slower, but you've actually got a disease that's a progressive, it's going to kill you. We don't have that test now. They can do brain scans, they can do things that are relevant, but at some point we will have an actual medical diagnostic test that is accurate. Maybe that will change things.
Hey, Chuck, you got a huge fan club. People, more than one person is like, hey, I want Chuck's email address. Chuck, is it okay if on the recording link that I add that? I can look up your email address. Okay,
Yes.
folks, I'll make sure to add that along with Lowrey. It's okay
To be
to add.
clear, you need both an advance directive and a healthcare power of attorney. But simply stating what you want is fine, but that doesn't appoint an agent who will work on to effectuate your wishes. So you need two documents, a living will and a healthcare power of attorney for the agent.
Man, this is awesome. All right, folks, this has been very thought-provoking and informative, and I love the fact that we were able to put this together. I'm going to get to work on getting this recording up ASAP. We'll get Chuck's email on there. We'll get Lowrey and Final Exit Network. Her contact information is going to be on there. And share this far and wide, folks, when we have this recording. This will be a great thing. This discussion would be a great thing to share with families that you're working with, get people to think a little bit differently about end of life. And we will definitely follow up with this with more discussions like this one. All right. Thanks so much, y'all. And we'll see you at the next one.
Thanks, Steve. Good to be with you.